Welcome back to SCOTUS Oral Arguments and Opinions. In this second episode of today, we'll discuss the June 12th, 2025 Supreme Court opinion in the case called Commissioner of Internal Revenue versus Zuch, case number 24-416. We'll first walk through the syllabus, discuss a couple case implications, and compare how Justice Gorsuch's persistent oral argument questions foreshadowed his dissent. Please note that this summary is read by an automated voice. The question presented in this case is whether a proceeding under 26 U.S.C. 6330 for a pre-deprivation determination about a levy proposed by the Internal Revenue Service to collect unpaid taxes becomes moot when there is no longer a live dispute over the proposed levy that gave rise to the proceeding. Justice Barrett delivered the opinion of the court, in which Chief Justice Roberts and Justices Thomas, Alito, Sotomayor, Kagan, Kavanaugh, and Jackson joined. Justice Gorsuch filed a dissenting opinion.
Justice Barrett's majority opinion. This case involves the jurisdiction of the United States Tax Court over appeals from collection due process hearings when there is no longer an ongoing levy. The dispute here began in 2012 when Jennifer Zuch and her then-husband Patrick Gennardo each filed an untimely 2010 federal tax return. Gennardo subsequently submitted an offer in compromise to resolve outstanding tax liabilities. This offer implicated $50,000 in estimated tax payments that the couple had previously sent to the IRS. Following the offer, the IRS applied these payments to Gennardo's account. For her part, Zuch later amended her 2010 tax return to report additional income, which resulted in an additional $28,000 in taxes due. But Zuch maintained that the IRS should have credited the couple's $50,000 payment to her account, entitling her to a $22,000 refund. The IRS disagreed and sought to collect her unpaid taxes by placing a levy on her property pursuant to its authority under 26 U.S.C. Section 6331A. Zuch requested a collection due process hearing to contest the levy. The appeals officer rejected Zuch's argument about the misapplied $50,000 tax payment and issued a notice of determination sustaining the levy action under Section 6330C3. Zuch then appealed to the tax court under Section 6330D1. During the multi-year proceedings before the agency and the tax court that followed, Zuch filed several annual tax returns showing overpayments. Each time, the IRS applied these overpayments to her outstanding 2010 tax liability rather than issuing refunds. Once Zuch's liability reached zero, the IRS moved to dismiss the tax court proceeding as moot, arguing that the tax court lacked jurisdiction because the IRS no longer had a basis to levy on Zuch's property. The tax court agreed, but on appeal, the Third Circuit vacated the dismissal, holding that the IRS's abandonment of the levy did not moot the tax court proceedings. Held. The tax court lacks jurisdiction under Section 6330 to resolve disputes between a taxpayer and the IRS when the IRS is no longer pursuing a levy. A. The tax court is a court of limited jurisdiction. Section 6330D1 grants the tax court jurisdiction to review an appeals officer's determination in a collection due process hearing. The scope of the determination determines what the tax court has jurisdiction to review. The court agrees with the government that determination refers to the binary decision whether a levy may proceed. Section 6330C3 requires the appeals officer to consider three things when making this determination, including issues raised by the taxpayer. The statute thus distinguishes between considerations that inform the determination and the determination itself. Here, Zuch's dispute about estimated tax payments was an input into the determination, an issue raised that the appeals officer was required to consider under Section 6330C3B. The determination, by contrast, was just the appeals officer's decision to sustain the levy. Statutory context also supports the government's position on the limited scope of the tax court's jurisdiction under Section 6330D1. When a taxpayer wants to contest tax liability, The default rule requires taxpayers to first pay the disputed tax before pursuing a challenge. Had the IRS simply offset Zuch's overpayments without pursuing a levy, her only recourse would have been a refund suit in line with the default rule. The IRS's proposed levy triggered Zuch's right to a collection due process hearing under Section 6330A1, but Section 6330, titled Notice and Opportunity for Hearing Before Levy, focuses just on the proposed levy. The hearing's scope tracks its purpose. Taxpayers may raise only levy-related issues. Given Section 6330's unwavering focus on levies and the default rule requiring post-payment suits, it would be strange if a taxpayer could use a Section 6330 appeal to resolve tax disputes that no longer have any connection to an ongoing levy. Finally, the court doubts the tax court has authority under Section 6330E to provide relief beyond enjoining a levy. Nothing in Section 6330E11 authorizes the tax court to order refunds or to issue declaratory judgments resolving tax liability disputes. While Zuch argues that authority to enjoin a levy necessarily includes the ability to declare the validity of underlying tax obligations, the tax court's authority to render such conclusions depends on the levy's existence. B. The tax court properly dismissed Zuch's appeal. The appeals officer issued a determination that the IRS's proposed levy could proceed. The tax court had jurisdiction to review that determination, to decide whether the levy could or could not go forward. As part of that review, the tax court initially had authority to determine whether the appeals officer's predicate conclusions, like whether the $50,000 should have been credited exclusively to Gennardo, were correct. But once Zuch no longer owed unpaid taxes, there was no basis for a levy and thus no relevant determination to review. The tax court lacked jurisdiction to opine on disputed tax liability independent of any ongoing collection effort. Zuch's recourse for alleged tax overpayments is to file a refund suit, which she has already done. Reversed and remanded.
Justice Gorsuch's dissenting opinion. Like many Americans, Jennifer Zuch wound up owing money on her taxes. When the Internal Revenue Service told her that she had failed to pay all she owed for 2010, her then husband responded by paying the bill. But instead of applying that payment to resolve her liability, the agency used the money to satisfy her husband's separate tax debt. The agency did so even after Ms. Zuch's husband insisted the money was meant for her tab, not his. Then, because it deemed Ms. Zuch's liability still outstanding, the agency sought to seize and sell her property in a levy. Ms. Zuch spent more than a decade challenging the IRS's moves before the agency and later the tax court. Finally, just as the tax court was poised to rule, the IRS moved to dismiss Ms. Zuch's case. It did not do so because it admitted its mistake in crediting her husband's payment to the wrong account. Instead, the agency told the court it had determined that Ms. Zuch overpaid her taxes in later years, and it had decided to keep, rather than refund, those overpayments to satisfy her disputed 2010 debt. So, the IRS continued, a levy was no longer needed, and the court should therefore dismiss the case. The tax court agreed, reasoning that the IRS's decision to drop the levy deprived it of jurisdiction over the dispute. I endorse the opposite conclusion. Ms. Zuch still had a live claim pending before the tax court. She argued that the IRS erred by failing to credit her husband's payment to her tax debt, so she owed the agency nothing for 2010. Had she prevailed on that claim, the IRS would have had no basis for keeping her overpayments in later years. Nothing prevented the tax court from saying as much. Today's decision holding otherwise leaves Ms. Zuch with no meaningful way to pursue her argument that the IRS erred or to recoup the overpayments she believes the IRS has wrongly retained. Along the way, the court's decision hands the IRS a powerful new tool to avoid accountability for its mistakes in future cases like this one. I conclude that the tax court possessed jurisdiction to review all issues addressed in the Office of Appeals determination, including whether the IRS wrongly concluded Ms. Zuch owed money for 2010. The fact that the IRS announced its intention to drop its levy is immaterial. Nothing in the statute suggests that the IRS can deprive the tax court of jurisdiction simply by withdrawing a levy. To the contrary, three key features of the statutory scheme preclude that conclusion. First, Section 6330D1 governs the tax court's jurisdiction. It provides that the tax court shall have jurisdiction over such matter, a phrase that refers back to the Office of Appeals' determination in the taxpayer's case under Section 6330C3. That command is mandatory, and it nowhere uses the word levy. The absence of that term is telling, given that Congress used it almost 30 times elsewhere in Section 6330. Had Congress wished the tax court's jurisdiction to rise and fall with a levy, it obviously knew how to say so. Congress's decision instead to link jurisdiction to a determination is one we must respect, not allow the IRS to rewrite as it pleases. Second, Section 6330C2 provides that a determination may address not just an up or down decision on a levy, but also other matters raised before the Office of Appeals, including a taxpayer's claim that she has no unpaid tax or underlying tax liability. The statute tells us that resolution of those issues forms the basis for the determination, Section 6330C, supplying textual evidence that a determination incorporates the considerations that inform it. The tax court itself has observed that its jurisdiction is defined by the scope of the determination, and as a result, it may consider challenges to the existence or amount of the underlying tax liability if raised by the taxpayer and resolved by the Office of Appeals. As we have seen, the Office of Appeals determination in this case expressly addressed Ms. Zuch's claim that she had no unpaid taxes or underlying liability for 2010. Third, Section 6330E1 grants the tax court the power to issue injunctions against any action or proceeding in respect of the unpaid tax or proposed levy to which the determination being appealed relates. That disjunctive phrasing suggests the tax court may enjoin any IRS action relating to the unpaid tax, even if the action is not a proposed levy. Potential IRS actions relating to an unpaid tax include various collection alternatives, Section 6330C2A, and decisions about whether a tax liability remains unpaid. Accordingly, had the tax court found that Ms. Zuch owed nothing for 2010, it could have wielded its remedial authority under Section 6330E1 to enjoin the IRS from engaging in any action to collect that debt. An injunction could stop the IRS from asserting its entitlement to retain Ms. Zuch's later overpayments. I conclude that the IRS seeks, and the court endorses, a view of the law that gives that agency a roadmap for evading tax court review and never having to answer a taxpayer's complaint that it has made a mistake. After today, Section 6330 proceedings are essentially risk-free for the IRS. It may pursue a levy and argue its case to the tax court. Then, if the tax court seems likely to side with the taxpayer, the IRS can drop the levy and avoid an unfavorable ruling on the taxpayer's underlying tax liability. Doing so will often prove only a small setback for the IRS because the agency remains free to pursue other collection methods, including keeping rather than refunding a taxpayer's later overpayments. The taxpayer will often find herself without any way to challenge the IRS's error or prevent the agency from keeping more of her money than it is lawfully due. Until recently, even the IRS would have agreed with all this. As the IRS once put it, a motion to dismiss is inappropriate in the tax court proceedings as long as a taxpayer, as here, still contests the existence or amount of her tax liability. Nor would it matter The IRS continued, if the taxpayer had already paid the disputed tax, a development that, pretty plainly, would avoid any need for a levy. Now, of course, the IRS has changed its mind and taken just the opposite view. But when the government switches position and advances a new statutory construction that tilts the playing field in its favor, no one should be surprised if its latest utterance isn't the most convincing one. At the IRS's urging, the court today upholds the tax court's dismissal of Ms. Zuch's claims. In doing so, the court embraces the agency's present view that the tax court is powerless to resolve a Section 6330 case once the IRS abandons a levy. But the three arguments the IRS advances and the court adopts in support of that conclusion do not come close to proving it. The IRS first posits that the word determination in Section 6330D1 refers to the binary decision whether a levy may proceed. So when the Office of Appeals issues a determination, the IRS says that office simply decides whether a levy is appropriate. And given that, the IRS extrapolates, the tax court's jurisdiction must also be limited to assessing the propriety of a levy. The statute the IRS imagines is not the statute we have. Congress did not say that a determination refers to a binary decision whether a levy may proceed. Instead, Congress said that the tax court may review the full scope of a determination, including its resolution of a taxpayer's unpaid tax or her underlying tax liability. Congress discussed levies in many other places in Section 6330, and it easily could have said that the tax court may review only a determination whether the levy may go forward. Yet nothing like that italicized condition appears in Congress's work. Next, the IRS suggests that the tax court's jurisdiction must be limited to assessing levies, because the only remedy it can issue is an order directing the government not to pursue a levy. Along similar but more restrained lines, the court expresses skepticism that the tax court's remedial authority extends beyond enjoining a levy. Whether full-throated or half-hearted, that argument too disregards the statute's terms. Remember, Section 6330E1 permits the tax court to enjoin any action by the IRS relating to the unpaid tax or the proposed levy. So if the tax court were to conclude that Ms. Zuch is right, that her husband paid her bill, and she owes nothing for 2010, then it could enjoin the IRS from pursuing any action to seek or retain money from her for that tax year, or from making any contrary decision about the matter. And as we have seen, that relief would effectively foreclose the agency from asserting any lawful entitlement to Ms. Zuch's overpayments in later years. The IRS's remedial theory suffers another flaw too. Sometimes, of course, developments during litigation that leave an Article III court powerless to issue any binding relief can present a jurisdictional problem. The Constitution, after all, authorizes federal courts to entertain only live cases and controversies, not moot ones where it is no longer possible to grant any effectual relief to the parties. But, as the court seems to recognize, that constitutional constraint does not apply to the tax court. Name notwithstanding, that body is not part of the judicial branch. Instead, it exercises Article II, executive authority as part of the executive branch. So when the tax court addresses a tax dispute and returns it to the Office of Appeals, it is just one executive agency advising another about how to enforce federal law in a particular setting, and even without an injunction compelling it to do so, the Office of Appeals may choose to follow the tax court's views when carrying out its duty to resolve tax controversies to the maximum extent possible through an administrative settlement. For taxpayers like Ms. Zuch, that may be all the relief they need. Without statutory text on its side, the IRS resorts to legislative history. Citing a committee report, the agency contends that Congress meant for Section 6330 proceedings in the tax court to be rare and few, and for most, challenges to the assessment of a tax to be brought in post-payment refund suits or prepayment deficiency actions in federal district court. That background rule, the IRS says, counsels against reading Section 6330 to allow the tax court to entertain disputes after the government abandons a levy. But even if refund suits and deficiency actions were once the usual ways for individuals to contest their tax liabilities, nobody disputes that Congress afforded taxpayers a new way of doing so when it adopted Section 6330. And taxpayers are entitled to expect that provision will be applied as written, not whittled down to a nub to suit the IRS. I recognize that today's decision leaves Ms. Zuch, after a decade of litigation, without resolution of her straightforward argument that the IRS erred when it concluded she had not paid her 2010 tax bill. The agency invites her to start over. All she has to do, the IRS says, is file a new refund suit in federal district court. There she can make all the arguments she sought to press in the tax court. And if she prevails, she can secure a refund of the overpayments the agency kept to satisfy her disputed 2010 debt. But that is no answer. More nearly, it is a trap for the unwary. The reason has to do with a statutory deadline. Taxpayers may not pursue refund suits until they have filed administrative claims with the IRS, something they must accomplish within 3 years from the time the return was filed, or 2 years from the time the tax was paid, whichever period ends later. Section 6511A. Yet a taxpayer who chooses to contest her tax liability in Section 6330 proceedings may not know that she needs to file such an administrative claim until the time for doing so has passed. Ms. Zuch's case illustrates the problem. The government deemed her 2010 tax debt paid when it kept overpayments she made in 2013 through 2016 and 2019. To seek the return of those overpayments, Ms. Zuch needed to submit an administrative claim with the IRS within 2 years of when the agency kept each payment. Yet, for a couple reasons, she did not know that she had any need to file a claim. For one, she was actively litigating Section 6330 proceedings, and understandably thought that was sufficient unto the day. For another, it appears the government did not tell her that she had overpaid her taxes in 2013 through 2016 and 2019, or that it intended to use those overpayments to satisfy her disputed 2010 tax liability until it moved to dismiss her case in the tax court. Consequently, Ms. Zuch had no reason to think administrative refund claims might be necessary or even available until that point. And by the time she filed a refund suit in district court, it was too late for her to submit prerequisite administrative claims for some, but not all, of the years in question, and thus too late for the court to adjudicate her entitlement to refunds for those years. So the IRS's invitation for Ms. Zuch to start over really turns out to be little more than an effort to deprive her of complete relief. I conclude that the IRS seeks, and the court endorses, a view of the law that gives that agency a roadmap for evading tax court review and never having to answer a taxpayer's complaint that it has made a mistake. After today, Section 6330 proceedings are essentially risk-free for the IRS. It may pursue a levy and argue its case to the tax court. Then, if the tax court seems likely to side with the taxpayer, the IRS can drop the levy and avoid an unfavorable ruling on the taxpayer's underlying tax liability. Doing so will often prove only a small setback for the IRS because the agency remains free to pursue other collection methods, including keeping, rather than refunding, a taxpayer's later overpayments. The taxpayer will often find herself without any way to challenge the IRS's error or prevent the agency from keeping more of her money than it is lawfully due. Seeing nothing in the law compelling any of those results, I respectfully dissent.
Case implications. This decision may create 2 headaches for taxpayers dealing with the IRS. First, it gives the IRS a get-out-of-jail-free card. Here's how it works. The IRS can threaten to seize your property through a levy, which triggers your right to challenge them in tax court. But now, if the IRS realizes they're about to lose that case, they can simply drop the levy threat and walk away. The tax court has to dismiss your case, even if you're right about the underlying tax dispute. It's like being in a courtroom where the other side can just say never mind and leave whenever they're losing. The IRS gets to avoid an unfavorable ruling while keeping any money they've already collected from you. Second, this decision creates a procedural trap that can cost taxpayers real money. If you're fighting the IRS in tax court and they pull this maneuver, you'll be told to start over with a refund lawsuit in federal court. But here's the catch. You have strict deadlines to file administrative refund claims with the IRS, typically within 2 years of when they took your money. If you were busy fighting in tax court, thinking that was sufficient, you might miss those deadlines entirely. By the time the IRS dismisses your tax court case and tells you to file a refund suit, it could be too late to recover some or all of your money. You end up losing not because you were wrong about the tax law, but because you got caught in a procedural maze that the IRS helped create. Now, let's read the oral argument tea leaves. Justice Gorsuch's persistent questioning proved remarkably prescient, foreshadowing almost every major theme in his dissent, while the majority crystallized around statutory text analysis that emerged during oral argument. Gorsuch began questioning early and maintained consistent pressure, cutting straight to the jurisdictional heart. You agree that the tax court's jurisdiction hinges on a determination? His persistent focus on whether the government had formally withdrawn the determination, has that determination been withdrawn, directly anticipated his dissent's emphasis that nothing in the statute suggests that the IRS can deprive the tax court of jurisdiction simply by withdrawing a levy. Most tellingly, his comment that the whole thing's crazy captured the frustration permeating his written dissent about IRS manipulation. His oral argument prediction of a powerful new tool to avoid accountability became his dissent's central thesis. Gorsuch's questioning revealed the IRS's changed position from previous guidance. That dismissal was inappropriate when taxpayers contested liability. This became prominent in his dissent. When the government switches position and advances a new statutory construction that tilts the playing field in its favor, no one should be surprised if its latest utterance isn't the most convincing one. The oral argument proved remarkably predictive of final alignment. Gorsuch's early persistent questioning clearly signaled his eventual dissent, while Jackson's textual focus anticipated the majority's reasoning. The fundamental battle lines were drawn during the justices' questioning, with Gorsuch's crazy observation proving prophetic of his comprehensive dissent. That's a wrap on Commissioner of Internal Revenue Service versus Zuch. Stick around. We have 4 more opinions from today's decision day coming up. Hope you enjoyed this episode. If so, please follow, share, and review.